I have been told to hold the microphone up. Nobody ever had any problem hearing me in the courtroom, I don't think. So, but anyway, we are glad to be here today. Tammy Jump is First Assistant DA in Bienville, Jackson, and Cleveland parishes. She has been teaching with the Drews for a long period of time, as well as I have. Of course, I'm Jeff Cox with the Louisiana Second Circuit Court of Appeals. Juliana Parks is y'all's attorney, and she's going to talk to y'all a little bit about qualified immunity at this point in time, and then Tammy and I'll come up and we will talk to you about the case laws and the changes in the legislature and go over the book with you just a little bit. So y'all listen to Juliana because she's probably your best friend if you ever get sued.
Thank you very much, Judge Cox. Good to see all of you. I know most of your faces, but if I don't know you, that might be a good thing, and nice to meet you. So before we get started on the qualified immunity stuff, I was asked to go over some questions that had come up about how to dress when you're called to court. If you were called in your capacity as a law enforcement officer, then you wear your uniform just as you would to work, and that's fine, and you can bring your gun with you. However, there is a new statute that's been passed, and I'm going to just read it to you. There aren't any cases on it yet. No state or local law enforcement officer shall carry a firearm, whether concealed or not, on his person into a courtroom while attending any session of state, parish, city, municipal, family, juvenile, drug, or traffic court as a party to the proceedings. So obviously, if you're the plaintiff or the defendant in the suit that you're appearing for, you can't bring your gun with you. Believe it or not, this comes up a lot, more than you think it would. The question then becomes, what if it's your niece is getting a divorce, or somebody you're there, for moral support, or because you know one of the parties or something like that. There's no clear answer because there aren't any cases on this yet, but most likely a court would find that that's not okay. So if you're just going to court to be helping a party or a witness not in the capacity as a law enforcement officer, then it's probably a good idea to leave your gun, not bring it in the courtroom. If you have any question, the best way to address that would be to approach the courtroom deputy and ask the courtroom deputy how that particular judge would like to handle it. So I actually think they had an issue with this a couple weeks ago, so we wanted to make sure everybody was aware of that and what the rules were regarding bringing your weapon to court. Also, we had a case a few weeks ago in federal court, and the defense attorney was arguing that the officers who were called to testify as witnesses should not be able to wear their uniforms. Obviously, that depends on the judge. It's what the judge wants. So you do want to make sure ahead of time before you show up to ask the attorney or whoever has subpoenaed you what you are supposed to wear. In that particular case, it was Judge Hicks. He said, if you are a detective and you wear plain clothes every day, don't show up in your uniform. If it's part of your everyday life to go to testify as an officer and that's what you're wearing, then by all means, you're able to wear that. And he actually said, I don't think I've ever seen Sheriff Whittington in a uniform. He wears a suit, so he better wear a suit when he shows up. So that's how one judge handles it, but again, each judge is going to handle that differently. So just make sure you find out ahead of time what you are supposed to wear. All right. The next thing we were going to talk about. Okay, and I did want to point you to the, it's in your policies and procedures number 3.01. It says, while representing the Bossier Sheriff's Office in any official capacity, a member's dress and appearance will conform to the Bossier Sheriff's Office policy. Courtroom attire shall be the member's seasonal duty uniform. Any exceptions shall be by order of the supervisor. So that's what your Sheriff's Office policy says about it. If you do find out from the attorney or the judge that you're supposed to wear something else, make sure and discuss it with your supervisor. Otherwise, just wear what you would wear to work every day. All right, let's see. So the next thing we're going to talk about, and I'm sure that you've all heard this over and over again, and that is qualified immunity. Qualified immunity is something that makes you immune from a lawsuit if you acted reasonably. And in order to understand that, you kind of have to go back a little bit and understand why you would be sued. So before Section 1983 of the federal law was passed, if you violated somebody's rights when you made an arrest, then the remedy would be that the evidence would be excluded, you know, the charges against the criminal wouldn't be good, but there wasn't any way to get a remedy against the officer for violation of constitutional rights. So Congress passed the Section 1983, which says if you violate somebody's constitutional rights, you can be subject to a civil suit or to criminal liability for that violation. And so that could be a problem, because then you're scared of, what if I accidentally violate somebody's rights? What if I didn't know that what I was doing violated rights? What if I thought I was doing the right thing and I made a mistake? You can get sued civilly for that. You know, it puts you in a bad position. So then they developed what's called qualified immunity. And you may have seen this, it's been a big topic in the news lately about whether qualified immunity should continue. Lots of people think that it shouldn't. Lots of people, even when I see this stuff shared on social media or on the news, and they're explaining what qualified immunity is, they get it wrong. Doesn't mean that officers can't be sued. What it says is, if you acted reasonably and you didn't violate any clearly established law, then you are immune from suit. And that immunity is an immunity from suit, which means you should be able to assert it at the earliest stage in the lawsuit. So sometimes you can get out on a motion to dismiss. It just depends on the facts. Sometimes a motion to summary judgment, you can get out. Sometimes you have to go all the way to trial, and the judge will say, well, the jury needs to decide whether this law was clearly established or if the officer was acting reasonable. But most of the time, you get out without actually having to go through the lawsuit. So how do you get qualified immunity? You have to be aware of what the clearly established law is in order not to violate clearly established law. And so that's why you have these in-services. We come in and we tell you, here's what the latest is. So what I'm going to try to talk about are, just in the last 2 years, what things have become clearly established by decisions of the Fifth Circuit or the Supreme Court that weren't clearly established before, so that you will know and you won't violate them and you'll be entitled to qualified immunity. You know, hopefully it will help you not to violate anybody's rights, but if you should happen to do so, then you would be entitled to qualified immunity, and Glenn and I can help you get out of the lawsuit a lot easier. So, one of the recent cases is of Bueller versus Deere. This is a Fifth Circuit case. And so for those of y'all who aren't familiar with the way the courts are set up, you have state court and you have federal court. Federal court, you have a district court. Our district is the Western District of Louisiana. You also have the several other districts. New Orleans is in a different district, and Lafayette's in a different district. So we are in the Western District though. And so all of Louisiana and Texas is in the Fifth Circuit. So that's called a controlling court. So what the Fifth Circuit says, the Western District has to do it. Now, then you also have the circuit that California is in. They do things a lot differently. If, you know, a different circuit in the United States that's not our circuit makes a ruling, that can be persuasive, but it's not controlling, okay? So when you're looking at qualified immunity, in order to know if it's clearly established, you have to know what's clearly established in your district, okay? So if you've got California and New York saying something different than the Fifth Circuit that we're in, obviously the Fifth Circuit's gonna control. Eventually, hopefully it gets to the Supreme Court, and once you do get a Supreme Court decision, everybody's governed by that. So not to bore you too much with that, but there is a difference in controlling courts and not controlling courts. In our case, the Fifth Circuit is the controlling court. So the cases I'm gonna tell you about today are all the recent cases out of the Fifth Circuit. Okay, so Bueller versus Deere came out in March of this year. This is a case about whether you can film officers. That's a huge thing now. People want to pull their phones out and film an officer. So filming is legal, but if they're hindering an investigation, it's not legal. So this case came up about whether the person who was arrested was hindering the investigation or whether he was just filming. So this was in Austin, and there was a guy, his name is Bueller. That's where the name of the case comes from. And he's called in the case a police accountability activist. So I guess that's what he calls himself, a police accountability activist. That's probably the first time I've heard that exact term, but it gives us a good idea about what he's doing out there. He's filming the police, making sure they're not violating anybody's rights. So while he's filming the officers, he gets very, very close. He's hollering out insults like pig and the F word and this and that at the officers, and they tell him, you have to stand back, stay away, you can't interfere, we're arresting somebody. And he continues to do it. He continues to get within arm's length. And so they end up having to take him down and arrest him, because when they go to arrest him, obviously, then he backs up and tries to run off. So he, skins up his elbow or something and files this suit saying his constitutional rights were violated because he has a First Amendment right to film the officers. So it goes to the Fifth Circuit, and they say, first of all, that the officers did not violate his rights. They had probable cause to arrest him for the law that he was arrested for violating. So it was a city ordinance or something that says you can't interfere with a police investigation. So they don't even have to get to qualified immunity, because remember, you only need qualified immunity if you actually do violate a constitutional right. But nevertheless, they go on and talk about it, and they say even though he none of his rights were violated, he also would be entitled to qualified immunity anyway. They talk about a case in August of 2015, and that would be the case that established the law that it's the right to film police. So this happened before August of 2015, so the law that you have the right to film the police was not clearly established at the time, so he would be entitled to qualified immunity had his constitutional rights been violated. So there you go. You can't arrest somebody just because they're filming the police. If you do, you're violating their right. That's clearly established. Now you will get qualified immunity, so don't do that. You can, however, set up boundaries that stop them from interfering with your investigation. If there are a lot of people around and you need to keep them back so that you can focus on what you're doing, that would probably be found to be a reasonable thing. You're not doing that just because you don't want them to film. You're actually doing it because you don't want them to interfere with what you're doing as an officer. All right, the next case is another Fifth Circuit case that came out in July of 2021, and this one's called Cope v. Cogdill. And this one, the inmate comes in saying he wished he had a way to kill himself. And so they put him on a suicide watch. He gets mad, he gets the plunger and starts beating up the toilet and is acting, pretty crazy. And somehow he gets a foam cord and wraps it around his neck. So the officer's standing outside the cell, sees this going on. He sees the guy strangling himself with a foam cord. They've already taken all the sheets and everything out of his cell so that he can't hang himself. He doesn't call for emergency services. He calls for backup. Obviously this guy's been acting crazy, doesn't want to go in the cell without backup, so he calls for backup. The officer to help him shows up, and then, by that point, several minutes have passed and the guy's passed out. And so at that point, they open the cell, they take the cord out from around his neck. The backup officer had called 911, and so, EMS doesn't get there for 5 or 6 minutes, and the guy eventually dies. So the question there is, was it a violation of clearly established law for him not to immediately call EMS, not to immediately open the door to the cell, and also to even have a phone cord where he could get it? And the court ruled that failing to properly call for emergency services was a violation of his constitutional right. However, it was not clearly established. There hadn't been a case yet that said, if you see someone killing themselves, you have to immediately call for 911, and so the officer was entitled to qualified immunity as to that violation of their rights. So if you see somebody that's, in a situation where they might die or they're trying to kill themselves, you have to call 911. That's clearly established now. All right, Ramirez versus Guadarrama. That's February of 2021, another Fifth Circuit case. In this case, officers respond to a call where a man's standing outside the house. He's threatening to burn the house down. He's threatening to kill himself, and he pours gasoline all over himself. So what do the officers do? He starts coming out after them, and they tase him. He catches on fire. The house catches on fire. Everything burns up, and he dies. And they sue the police and say they violated his rights because they should have known not to tase him when he had gasoline all over him, and that it's their fault that all this stuff happened. And so the court says, yeah, this is a very tragic situation, obviously. However, what were they supposed to do? You know, if he started coming after him and they shot him, you know, that could have ignited it, you know, somebody could have gotten hurt, he could have hurt his family, he had mentioned he wanted to kill his family, and so they said, you know, look, we weren't there, this was a tough situation, there really isn't a clear answer, you know, we can't sit here in our courtrooms behind the door at our desk and decide how they should have handled it at the situation, and so they were entitled to qualified immunity. There was no clearly established right that was violated there. And then finally, there's Villarreal versus the City of Laredo. Actually, I was going to skip that one. It didn't really do much. Okay, Solis versus Sims. That's April of 2022. That's a Fifth Circuit case. They found the officers did not violate clearly established law. In this case, they made a traffic stop for a suspected DUI, and the girlfriend is a passenger. The driver is an African-American man, and the girlfriend is white, and so she's hollering at the police the whole time saying, you're just picking on him, you know, you're racist. They ask him to step out of the vehicle. She starts filming it with her phone. She gets out, you know, is getting in the way. They say, look, you need to get back on the grass. You know, you're gonna get hurt. She says she's not drinking, but clearly she's intoxicated too. So finally, the officer says, give me your phone because I'm about to arrest you and I don't want your phone to get messed up. And she says, no, I'm not going to give you my phone. So the question there is, was she arrested because she was filming, or, you know, was it a legal arrest? The court said they can't say that her constitutional rights were violated, and even if they were not clearly established at the time of the violation. So what you're looking for here, you hear these buzzwords like clearly established, but what it means is, you know that people have a First Amendment right, you know what the rights are, but does this particular activity with enough specificity for you to be able to come to the conclusion that that right was violated? That's how it has to be for it to be clearly established. And so they said, nope, not clearly established here. You are entitled to qualified immunity. So, and then I liked this case because there was some good language they talked about what it takes for a right to be clearly established. And so here's some language, because that's all you have to work with court decisions, is language that the court gives you to kind of give you an idea of how they would rule in a particular situation if it came before them. So they said, you must be able to point to a controlling authority or robust consensus of persuasive authority that defines the contours of the right in question with a high degree of particularity and have placed the statutory or constitutional question beyond debate. So in order for it to violate a constitutional right, it has to be beyond debate that what you did violated that right. A sufficiently high level of specificity to put the reasonable officer on notice that his conduct was unlawful. So it's clear that the Fifth Circuit does not want you to get in trouble for things that you didn't know were wrong, and so they do allow you to assert qualified immunity. They are still recognizing it, as you can see through these cases in the last year or so. So as long as you stay up to date on what's clearly established and do your best to follow it, you should be good, and we should be able to assert that. You don't have to be afraid to do your job. I know that's very important, that you got to be able to act without having to worry about getting sued. So rest assured that's still there. So the final thing that I want to talk to you about is, what do you do if you receive a subpoena or a lawsuit? So as soon as you receive the subpoena or the lawsuit, make sure that you contact your supervisor and that they contact the risk manager so that he can make sure that it gets calendared. We've also worked with the clerk's office because we were getting subpoenas for family law cases, and they were like, you have to show up tomorrow for court. Well, technically you do have to. However, you know, for scheduling purposes, that becomes a nightmare from the supervisor's standpoint. So we have to be able to keep up with those things so that if it does become a problem, we can go to the judges or we can go to the clerk and be like, hey, these lawyers are doing this. You know, we don't have, you know, there's a shortage of officers. We can't pull people off to come sit in court all day to testify about your family law case. So we keep statistics of that sort of thing, and so we do need to know that. And also, we need to make sure that if you do want a lawyer there with you when you have to go testify, that someone is available, and that takes a little time for us to get that together. Also, if you're subpoenaed to testify and you're not on the clock, you should be entitled to be paid for that. If you're on the clock, it's considered to be part of your duties. So the money goes to the sheriff's office since they're already paying you your salary. However, if you're called in, it's not very much, it's like $30, but hey, $30 is $30. So make sure you ask about that, because if you don't, if you show up, and especially if you don't have an attorney there with you, the lawyer that has subpoenaed you, you can ask him and say, hey, where's my check at? And you can email me if you need the statute on that, or if you need some help collecting. So, and then, let me see, I think that's it. And if you receive a lawsuit, obviously you only have a certain amount of time to respond to that. Make sure that there's insurance to cover it. There's different notices that has to be done. So it's very, very important that as soon as you get served with a lawsuit, that you do let your supervisor know and make sure that the information gets to the appropriate parties. Also, when a lawsuit's filed, I'm sure you've all seen the emails that go around that say, if you have any evidence about this, make sure that you keep it. Don't erase any emails. Don't get rid of anything that might be evidence in these lawsuits. So that's very important for your department to do. So that's all I got today. Anybody have any questions about any of this? I know it's just boring, kind of, but it's also important. So I appreciate you listening today, and good to see you all. Good luck.
Thank you for being here today. It's very, very important material that you have shared. I know that they will remember that when they get their first lawsuit. So let's put it that way. So we appreciate you being here today.
All right.
Thank you for coming out. We're going to play a video from Judge and Miss Drew. Now, Tammy and I can tell you that Judge and Miss Drew are totally missing y'all. They wish that they were here. Depending on which day Judge Drew is feeling like, we get 15 emails if it's a good day and only 10 if it's a bad day. So he is a little bit taking care of everything still. So we are glad to have them.
Hello everybody, I'm Harmon Drew, and this is my friend Gene Drew. Talk to him a little bit.
Hello everyone. Harmon and I are really missing being able to come to the classes and see you all. We like to hug our old friends and meet new law officers as you all come on board.
That's enough, I'll take it. We really miss coming to your town and seeing you. You need this education because post requires it. You need it to be a good officer. And it's like, it's a protection against civil suits, the fact that you kept up with the law. Now, Tammy Jump and Jeff Cox have been teaching with us for 10 years and 12 years respectively. And we ask them stuff now. And they are just the best people in the world and the best teachers in the world, and I know you'll treat them with courtesy. Jane?
One thing that we've all learned, even if you're a brand new law officer, you know now that there's no point in worrying about the future because life has a way of turning out completely differently than what we expect. We have a pandemic that it hopefully is almost over, and we've also had an illness in our family that we never foresaw.
Poor me.
I know, poor Harmon. But the good news is he's getting better and stronger, and we're really hopeful that before too long his doctors will turn him loose so that we can come and see you all in person again. We want you to know how much respect we have for what you do. You've chosen a difficult profession where some people just want to fuss all the time about who you are and what you do. But those are the very people that when something bad happens, they're going to be hollering for your help and your protection. But you all have been well trained and will respond in the most professional manner possible. And we are so proud of you and thank you for your service.
Thank you for protecting, thank you for serving, and may God bless you. Thank you so much.
You don't know how this is killing him not to be here. But anyway, we are glad that y'all are here today. We appreciate y'all being here. We will go through the material. We're going to take and be a democracy. How many of y'all want a 5-minute break during the middle of this? Raise your hands. How many of y'all want to go straight through? How many of y'all did not raise your hands? Raise your hands for me. I just want to make sure you're alive. We're going to go straight through anyway. I was just going to give you a vote. I wasn't going to follow it. I mean, all right. Okay, Ms. Tammy.
Okay, Sarah, this thing's blinking red, so the battery may go off in a second. Can you hear me? Can y'all hear me?
What color is that light?
Green.
Go ahead.
Okay. Okay, she's got me now. So back in July of 2020, y'all know what happened. We made one of the biggest mistakes we've ever made in this state by raising the age to 18. If you're under the age of 18, you're considered a juvenile. What I really didn't pay attention to in that time was the fact that as a felony prosecutor, I could transfer juveniles to adult court by either a grand jury indictment or by doing it in juvenile court. But after that, I just assumed if they're transferred to adult court, they're considered an adult, right? They ought to go to big boy jail. That's not how it works. If they are, even if they're transferred to an adult court, they still have to be housed in a juvenile detention center or an adult facility, but they have to be out of sight and sound from any adults. Well, I don't know about y'all, but in Bienville Parish, we don't have that capability. So our juveniles that are transferred to adult court for, say, committing an armed robbery, they have to go back to a juvenile detention center. Justin and I were talking about how the issues that we're having with these juvenile detention centers all over the state. They're over capacity. Ware is over capacity. We paid $27,000 to house a kid for 20 days at Ware because we were paying the day rate for him, plus we had to pay the penalty that Ware was being charged for being over capacity. So my police jury had to pay that for a kid to stay there for a home invasion. They're talking about building a facility in Alexandria, which y'all know as well as I do, that could take 2 or 3 years, if not longer. They're also talking about using a camp at Angola to house some of our juveniles. So I think that's a great idea, but I can see the issues with defense attorneys and things like that. So anyway, this is a problem. You still have to just keep that in mind. If you're dealing with juveniles, you have to take them to a juvenile detention center. They cannot go to an adult facility. The crimes of violence, they added false imprisonment when the offender's armed with a dangerous weapon, and they also added possession of a firearm when you've been convicted of certain felonies. They added these two to the crimes of violence list. Now, we tried to get, remember we told y'all last year we were gonna try to get resisting an officer by force or violence added to the crime of violence list. So we tried, and it got through the House, no issues, got through the Senate, no issues, it got to your governor's desk.
Your governor's
Your
desk.
governor's desk. And he vetoed it because he said it was not.
We'll put it this way, he's our governor, but I didn't vote for his ass.
Right.
Okay.
Me either. So he vetoed it because he said it was not in conformity or some other word like that with
It was
his,
not in conformity with the
with his-
criminal justice reform
with
bill.
his criminal justice reform. I really don't know where that he even gets at, but for whatever reason, he vetoed it. So we're gonna continue, as long as we're here, to try to get that added to the crime of violence list. What that does is, it just means instead of only serving 25% of the time that they get, which is all they serve now, and the max is only 3 years. So I could max them out, give them 3 years, and they'd only have to serve 9 months of that sentence. What it does is when it's a crime of violence, they have to serve about 65 to 75%, depending on their criminal history. So that's what we were trying to get done, was that they would have to serve more of that time, whatever time they get. But he vetoed it. We're gonna try again next year, and then maybe sometime in 2024, we may be able to get a better governor.
It got passed pretty much unanimously.
Yeah, it did, in the Senate and the House.
Right. Okay, guys, I get to talk about the tough stuff. We're not here to talk politics about abortions, okay? And I hate to tell you that. Supreme Court has made a decision, the Dobbs decision, y'all know about that. Our legislature passed a ton of laws about abortion. This is physician-assisted abortion, pills, if you're talking about anything at a hospital, anything of that nature. There are a ton of laws on the books talking about abortion, and that it is totally outlawed abortion. There is no exception for rape, incest, or life of the mother. So these laws are on the books. They have been passed by our legislature, they've been signed by the governor at this point in time. Can you enforce these laws? No, not at the present time, but you have to be aware that these laws are out there. There's gonna be a lot of litigation on this. This will go up to the Louisiana Supreme Court. It may still go back to the United States Supreme Court, depending on what happens. The difference between abortion and feticide is still a valid law that you can charge. It is still a valid charge that you can make. Feticide is where somebody that is not a physician does something to cause a baby to die. So basically, in that situation, if you have a baby that dies because somebody hits a pregnant woman in the stomach and the baby dies, you can charge feticide. But these laws are out there, you need to be aware of them, and there are a ton of them that have been passed this year by the legislature.
Battering a police officer, they added juvenile detention officers to the definition of a police officer. Like Justin and I were saying, I don't know why they haven't already been in there, but they added that this year. Kenny Lofton from Ware contacted Judge Cox and asked if they could be added to this definition. I'm assuming what's going on is they're being battered down there, and it's probably only been able to charge with simple battery. Now they can charge with battery of a police officer because they've been added to that list.
And let me say this real quick. Guys, we're always watching the legislation. We're always working with our state representatives and our state senators. We try to work with our public officials. If you see something in the law that needs to be amended or changed, I'm not above going and asking. Tammy's not above going and asking our state representatives and senators. They represent you. I serve you. Even though I'm elected to the court and I interpret the laws, I still am a public servant that serves you. And we're going to do everything we can to protect y'all in every way that we can. So if y'all know something that we need to know about, please let us know. If we find something that you need to know about, like the qualified immunity bill that we got killed last year, we'll let you know about that also. So please keep us advised.
Okay, the next few slides we're going to talk about are about things going on in hospitals and with emergency room personnel and healthcare professionals. This statute, they changed the definition of healthcare professional to pretty much mean anybody that comes into contact with a patient. So they added these definitions to it, and obviously you can't batter any of these people. And assault, same thing. They added, it has the same definition of healthcare professional. You cannot put somebody in reasonable apprehension of receiving a battery, just like any other assault. It is a misdemeanor. And then unlawful disruption of the operation of a healthcare facility. This is kind of a little similar to terrorizing in some senses. It's if it places people in reasonable apprehension of anything, if somebody threatens that there's a crime of violence that's about to happen, anything like that disrupts the healthcare facility, then you can arrest them for that and put them in jail, and it is a relative felony. I'm guessing this has got to be going on. I know some things have happened at Minden Medical, so I don't know if it's happening around here or not, but they've added these statutes so that you will have something to be able to charge these people with.
Terrorizing this year added the word menacing. Basically, in the past, it had not included menacing, but menacing is the intentional communication information that the commission of a crime of violence is defined in 14.2b, is imminent or in progress. And it talks about the situations that happens. Y'all remember the incident that happened over in Minden where somebody screamed gun in the stadium and everybody started ducking? If they could have found somebody that witnessed somebody screaming gun, which nobody heard anything really, but they said it happened, they could have charged this statute under terrorizing because menacing now. So that has been amended. Know that that is out there under our code at the present time.
Okay, Ray? Now, how many detectives do we have in here? We now have, you I'm scared to raise your hand, I know a bunch of you boys back there with ties on are detectives. Rape now includes foreign object penetration. Does not have to be the genitals of the offender or the genitals of your victim. It can mean foreign object penetration. So they changed this. I'm thinking it's probably because these guys think they're getting smart, especially when you've got minor victims and they are using different things, thinking that they're not going to leave DNA. So this does include that. And also they changed, instead of now, it used to be physical infirmity or mental infirmity was one of our victim classes in first degree rape. Now they've changed it to persons with a disability, and they define that as a person with mental, physical, or developmental disability that substantially impairs their ability to provide for their own care or protection. I just had one that we took to the grand jury. The woman's in her 40s. She cannot take care of herself. She cannot hold a job. She can carry on a conversation with you. So initially, maybe just talking to her, you wouldn't think that she had any kind of disability, but she cannot take care of herself. She's still living with her mother. So I think this will help us be able to more clearly define somebody that might fit underneath the first degree rape statute.
Let me say this, if you're working as a detective, one thing that I would check, you can always check school records potentially to see if that person has been in a special class. You can check the courthouse records to see if that person has been interdicted. That is another thing. If they are interdicted, I believe that they fit under this. And there's a lot of people that are special needs type of people. There are people that are more elderly that are having problems that have been interdicted. So that will help you to be able to find the elements for this case if you're dealing with a first degree rape. Second degree kidnapping and aggravated kidnapping of a child, they've updated both of these statutes and now defines the term sexually abused. The reason, and we try to look behind why these laws have been passed, we believe that this is dealing with a lot of sex trafficking that's going up and down the highway, human sex trafficking. I-20 is a corridor. I want you to understand that that is a corridor. One of the last cases I had in Bossier Parish as a district judge was a case that there was a young lady that was arrested for prostitution in Bossier Parish. She was 17 years old. Her family came up, the FBI called me that day and told me that this family was coming up and that this little girl had been exploited as a child. She had been basically kidnapped at the age of 13 years old. And she was found at 17 years old. She had been exploited all the way from Los Angeles, all the way to, they told me to speak up. I'm trying to do that. Now it's reverberating. Okay, gotcha. All right. See what trouble you get me into? But basically, this young lady had been taken all the way from Los Angeles, all the way to Georgia, up and down the highways. Now, y'all know about 3 weeks ago, we had a sex ring that was broken up over in Caddo Parish, a 19-year-old and a couple of 28-year-olds with young females and guys, I guess. But the thing about it is, on I-20, y'all are working I-20. If you see a young person in the vehicle and they're not related, you need to be thinking about this because there is a lot of sex trafficking that is happening up and down our highways at the present time. But these statutes have been added.
Okay, simple criminal damage to property, they've made it a little easier for us to get to a felony. If you have a number of distinct acts, but they're part of a continuous sequence of events, you can add all of that up, all of that damage up, and maybe get you to a felony. So in other words, if you got a guy going down the street, busting out windows in houses, and it might be that one house that the damage was only $200, the next house it may be $250, something like that, which normally you would have separate victims, and so you have a misdemeanor, 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 misdemeanor. If it's a continuous sequence of events, add them all up. All those people would be your victims, but add them all up, and then you could arrest him for a felony if you get over $1,000. So they've made it a little easier for us to get to that. And we have a lot of this going on nowadays, especially these people that are breaking in, even just damaging stuff, and we can get to a felony, hopefully.
Carjacking has been increased in penalties. Now, Basically, if you commit the crime of carjacking and there's serious bodily injury, that carries 10 years or more than 20 years. That's without benefit of probation, parole, or suspension of sentence. They also made effective 64.2.1 that a person over the age of 17 cannot intentionally recruit or aid or solicit or encourage any child under the age of 18 to commit the offense of carjacking. Now, this is one of those statutes that we're trying to get where we go back to just saying that if they're over the age of 17, then they're an adult. Because this is kind of confusing the way that they write this, and we have to look at this. But a 17-year-old, basically, if they're arrested for this offense, they have to go to a juvenile detention facility at that point in time, and they don't get to go to an adult detention facility. The reason all of this came out is, y'all remember the case out in New Orleans where the elderly lady was in the car. They carjacked the car, her arm got hung up in the seatbelt. She was drugged down the street and died. So they are passing stiffer penalties of this, but carjacking is happening over in Caddo Parish all the time. It's a lot of gang-related type activity that's going on. And I think there was somebody that was actually tried to be carjacked the other night.
Okay, simple robbery, they added the second paragraph, which is the taking of anything of value when someone is a part of a group of 3 or more individuals, and you take that from the retail employee or employer, and it's in their immediate control, and there's a reasonable belief that a reasonable person could not intercede or would not intercede because of fear. So they added this to our simple robbery statute. You know, simple robbery, they don't have a dangerous weapon. That would be armed robbery, but they don't have a dangerous weapon in this particular situation either. But again, this stuff's probably coming out of New Orleans, Baton Rouge, areas like that, where these gangs are going in to just like your local Super Save or Shop and Save or whatever they're called, or Circle K or whatever, and the clerks, they're taking stuff from the clerks, and the clerks don't feel like, if they feel like if they do something that they could be hurt or killed. So they don't intercede, and that's taken from them. So they added this, now it is a simple robbery.
All right, how many of y'all have had theft of catalytic converters? See, there's always somebody in every class that has a theft of catalytic converter. Basically, theft of catalytic converters has been added to the code. The penalties are the same as theft, though, all right? Every year, what do? We add more statutes that deal with theft. Basically, basic theft covers everything, but they wanted to add theft of a catalytic converter because it's costing the insurance industry a lot of money. It's costing individuals a lot of money. And how many of y'all that have had a catalytic converter stolen has taken, because of supply chains, a while to get a catalytic converter back in? So they put this in the code. Now, we had down to basic theft about, 4 years ago? We basically said, hey, let's just talk about basic theft. We didn't have theft of livestock, we didn't have theft of timber, we didn't have theft of crawfish. They put back in theft of alligators, but I got a solution to that. If the alligators win and let him go, we don't have to prosecute at that point, okay? But the other side of it is these penalties are the same as basic theft.
Okay, unauthorized use of a motor vehicle, as y'all know, it has been a felony for years. It's been a felony. But we did have unauthorized use of a movable, which could be a misdemeanor or a felony, depending on how much the movable cost. If it was less than $1,000, it was a misdemeanor. Over $1,000, it's a felony. Now they've amended this statute to add unauthorized use of a motor vehicle that's under $1,000. It is a misdemeanor. Normally what I would do...
They're shaking their head because they don't know where a $1,000 vehicle is.
Yeah, well, Castor and Ringgold have plenty of vehicles that are under $1,000, trust me. And my crackheads are the ones taking them because their buddy said, oh yeah, you go down to the store and get us some beer, and then 5 hours later they're not back, and so they call the sheriff's office and says, so-and-so stole my car. Y'all know
Because
how
the
that
bar broke down.
yeah. So they've added this. Usually what I would do, if the car wasn't worth $1,000, I would amend the charge to unauthorized use of a movable less than $1,000 and let the guy plead to a misdemeanor. Now they're giving me this where I can just say, okay, it's unauthorized use of a motor vehicle under $1,000 from the very beginning.
illegal carrying of weapons. You remember last year, the legislature amended this where you could carry your switchblade on the outside of your pocket as long as it was on the outside of your pocket. Now they've amended it that you can carry your switchblade in your pocket, along with your spring blade knife and all knives that mechanically open, okay? So basically, they've added this to the law this year. The other thing is, they said that retired justices of the peace are added to the list of people, as long as they're not prohibited from possessing a firearm and as long as they are post-certified, they can carry a concealed weapon, along with investigators and retired U.S. attorneys. The other thing is, they updated the law this year to allow military. If you are retired or active military, you can carry a concealed weapon without a concealed weapons permit, okay? So you have to know that. But the person that is military, whether they're retired or whether they are active duty, they have to have proof on their person that they are retired or they're active duty. So if you pull somebody over, this is what I want to tell you. 3 years ago, Governor signed a bill into law that if you're escaping an emergency, for example, a hurricane, for 72 hours, if there's a declared emergency, you run out of the house, you grab your gun and you stick it in your pocket, you can carry that gun without a concealed weapons permit. This year, the governor allowed you to carry spring blades, switchblades, all kinds of knives in your pocket without illegal carry. Now you've got retired military. We're in a retired military community, correct? So now, if they're retired military and they have proof on their person that they're retired military, they can carry this weapon concealed, and it's not illegal carrying of a weapon. That puts you, if you're stopping people, you need to be asking for your safety. What's the number one rule at night? Go home to your family, right? You need to know that there's a lot more people going to be carrying weapons in this community. So one thing that you need to do is ask, do you have a weapon on you or around you or in your presence? Now, most of these people are not going to cause you a problem, especially retired military usually is not, or people that are in active military. But the other side of it is, guys, get home at night safely. Know that these people may have these weapons on them. Ask for your safety is the number one thing that I'd like to tell you.
Okay, I put this at the bottom, the 1495E. Where are my narcotics guys? 1495E, y'all know that's the illegal carrying of a weapon part that is a felony. The other parts of that statute are misdemeanors. Illegal carrying of a weapon, just having it concealed and you're not supposed to, that's a misdemeanor. 1495E is a minimum 5-year sentence at hard labor if you have dope with a gun, right? I tell my guys in Bienville, don't arrest somebody for illegal carrying of a weapon, 1495E, if they've got personal use, anything, cocaine, meth. I've talked to numerous prosecutors around this state, and this statute is kind of reserved for our dope dealers. I mean, it's reserved for our bad guys, the guys you run their criminal history, and they've transported dope, or they've got other weapons charges, or stuff like that. But somebody that's just got a little personal use marijuana, or personal use even cocaine or meth, you've got probable cause, and my guys still arrest for it, but I'm not going to charge them with it, and I tell them don't get their panties in a wad when I don't charge them with it. I'm just not going to. I may charge them with illegal carry and the misdemeanor if they concealed it on their person, and then the possession charge, but I'm not going to charge them with the illegal carrying 1495E. And what they added to this statute last year, remember, what do you have to do if you've got 14 grams or less? What? You gotta write them a summons. You can't arrest them, right? Y'all remember that? You cannot arrest them if you've got 14 grams or less. You have to write them a summons. And they put this in that statute, if they've got 14 grams or less of marijuana, you cannot arrest them for illegal carrying of a weapon, 1495E. So just know that and know what you're dealing with. Okay, cruelty. They added that the judge can order that the defendant pay for the vet bills, anything that has been incurred by the vet. I've prosecuted 10 people in the last 6 months for aggravated cruelty to animals. mostly dogs, some horses, but mostly dogs. Y'all watch the ASPCA commercials when they come on? Where
Don't encourage
where
her.
the arms, in the arms of the angels is playing in the background. I always have to turn it off because my dogs don't like watching that, but, because they're fat and happy. But, so these dogs, my Bienville Parish cases, I could have made a ASPCA commercial on these dogs. I mean, it was awful. And of course, the defendants claim, well, we don't have any money, and that's the reason why we couldn't feed the dogs. So, I mean, this was a good idea, I guess, but Judge Fallon can order all day long for my people to pay the money back to the Jonesboro Vet Clinic, who went and picked up 16 dogs at one house, but they're never gonna get their money, because what's gonna happen? They're not gonna get it. Probation and Parole is gonna file something saying that they're not paying what they're supposed to pay, and then they're gonna come to court, and they're gonna say, well, Judge, I don't have a job, and the judge is gonna go, okay, well, we'll just continue on probation. It's just like a vicious circle. So, this was a good thought, but in reality, I don't see how it's gonna really help us very much.
Go
Now,
ahead.
y'all want to encourage him on this.
Yeah.
So, the odor of marijuana cannot be the basis for probable cause to search a house without a warrant.
Okay, my question is,
Don't encourage him.
my question, how many of y'all think marijuana is gonna be
Don't raise
legal
your
in the
hands.
next 5 years? Raise your
Don't
hand.
raise your hand.
Well,
Well, see, it's
I see
less,
double
though.
hands going up, yeah.
It's less.
Hey, basically marijuana is gonna be legal
No,
probably
don't
in the
say
next
that.
4 or 5 years. Am I encouraging marijuana to be legal? No, I think it's a gateway drug. But every time we come up with something out of the legislature, what's happening? They pass something on marijuana. It's getting more and more difficult for people to go and investigate, especially if they open the door and the marijuana hits you in the face. Used to, you could do a lot of things. Now you can't do nothing except look in the house and see if there's pills. But this is a problem because y'all remember about 3 or 4 years ago, I talked about the BCD oil or what, the cannabis oil. Basically, that the drug dealers would start putting that in the vehicles. What do you think they're gonna do with marijuana now? If I sprinkle a little bit of marijuana in the car, and I can get away with a citation, and I can get my drugs up and down the highway for about a $250 fine, you think I'm gonna do that? What does that mean for you as officers? It means that you need to be on your toes and really looking, because I believe that the drug dealers are gonna get smarter and smarter. They also had to quit training or starting to train drug dogs not to alert on marijuana, because this is becoming a problem. Don't go out of here and say, Judge Cox said marijuana ought to be legal. No, I'm not saying that, okay? But I am saying this, you know, if it becomes legal, I know everybody's gonna have the munchies, so y'all can come to Judge Cox's Pizza Shack at that point in time, all right?
We just need to look at Colorado and what's been going on in Colorado. They legalized it, and look at what's happening up there. Okay, has anybody in this room ever seen a legitimate medical marijuana card from the state of Louisiana? We have now taught probably
12.
500
We've been
patrol.
12 parishes, yeah.
Yeah. Nobody has seen a legitimate medical marijuana card. But they added this in the legislature. They got a legit medical marijuana card. You cannot arrest them if they've got paraphernalia to smoke that marijuana. Okay? We have not seen anything. We had one Minden police officer who said that a guy she stopped had some kind of prescription on his phone, and she didn't really buy it, so she went ahead and I think it was over 14 grams, so she went ahead and arrested him for the possession of marijuana and told him he could show the judge whatever his prescription was. So, which I think was a good call. And I would have told her, if she'd called me, I would have told her the same thing, because she can't make a call on the side of the road about whether that prescription is legitimate or not. So, but they did put this in the code, in the statutes this year. Okay, y'all know that if you've got a domestic, a violation of protective order, a battery of a dating partner, stalking, they need to go to jail. Even though those are misdemeanors, and most misdemeanors you can write a summons, they need to go to jail. We think this is coming out of New Orleans, where they've got kind of a overcrowding of the jails down there. and they were writing summonses to people for some of these serious misdemeanor offenses, and they added this so that you know that these don't apply to these cases, domestics, battery of a dating partner, violation of protective order, and things like that.
Okay, guys, they have added a whole list of new drugs to everything. Okay? This is a whole list. Now, if we go to the next page, if somebody was to tell me what number, how to pronounce number 88, which has every alphabet almost in the letter in the alphabet, y'all want me to tell you how to say that? Because I know that because you want me to tell you how to say that if you have to go to the courtroom just in case? I don't want you to get embarrassed on the stand. How many of y'all want me to tell you how to say that if you go to the courtroom? Everybody wants me to say that? Okay. All right, this is the way that you testify to it when you get up there. Judge, this person violated number 88 in this statute. All right. So, all right. But anyway, they've added a number of drugs to the statutes this year. A lot of them have to do with fentanyl. A lot of them will do with methamphetamines. You need to look at these that have been added to the schedules. They've made some things regarding heroin, carfentanil, and other types of fentanyl. Now, y'all know that fentanyl is one of the main drugs that's coming across the border right now. Y'all understand that it doesn't take but a dot of fentanyl to kill you, right? So please wear your gloves. Please have your Norcam with you. We had 2 officers in other parishes in the last year or 2 that had a guy that went down. They touched the guy without gloves on. He had fentanyl on his skin. They both went down and they were both hospitalized because of that. So fentanyl is a very, very dangerous drug, and we do not want you to have that problem. If we're dealing with fentanyl, when they distribute fentanyl or carfentanil, or they are distributing heroin, that penalty is now from 5 to 40 years, and it's a fine up to $50,000, and the first 5 years have to be served without benefits. So they are taking this very seriously, but we know a lot of this is coming across the border.
And y'all need to be careful too, especially around these school kids. All that stuff coming, that looks like candy. We had a Webster Parish deputy that said that they found fake Xanax pills that were laced with fentanyl. So the pills themselves were nothing, but they were laced with fentanyl. And they were selling them to be Xanax pills, but they were laced with fentanyl. I mean, that's the reason why they upped this penalty, because people are distributing this stuff, and even if it's something just laced with fentanyl, it's causing serious bodily injury to people. They're becoming unconscious, things like that, and so that's why I believe that they enhance these penalties.
Okay, guys, this is a statute that is very serious, and I mean, I hate to have to even tell you about this. We know where this is coming from. The legislature passed this year. Basically, if you willfully and knowingly subject any person to the deprivation of any right or immunity secured or protected by the United States Constitution or the constitutional laws of this state, if there's serious bodily injury or death, you can be charged with malfeasance in office. And I'm going to discuss a case, or we're going to discuss a case in just a little bit, where I'll show you where this is probably going to be applied, and it just came out in the last year. But the thing about this is, everybody sues you every time that you arrest somebody. If they're going to sue you, they're going to sue you for a Fourth Amendment violation, a First Amendment violation because you kept them from speaking, 1983 action under constitutional amendment. And you heard that. You heard Julianne talking about that. But the thing about it is, if there's serious bodily injury involved in that, or somebody dies from that, now, not only can you lose everything that you got because of civil liability, now they can come back and charge you criminally and place you in jail if that happens. So this is a criminal liability statute that if you go to trial and they find that you violated somebody's constitutional rights and it caused serious bodily injury, and we know that serious bodily injury is what? Lacerations, unconsciousness, near-death experience, things like that under 14.2c. It's all defined the same way now. Basically, you not only have the penalty of civil liability, you have the penalty of going to jail for that. This is okay, I got news for you. Okay. If there's photographic evidence of a license plate on a vehicle which litters disposed, there shall be an inference that the register on the vehicle has violated the section. Does anybody see any problems with that? Raise your hand if you see a problem with that. Okay, the rest of you raise your hand if you're alive out there, all right? Okay. Basically, how do you know I'm driving the vehicle? Just because a piece of paper comes out of the vehicle, was I driving the vehicle? Was I even in the vehicle? How many of y'all have kids that you let drive your vehicle, that they have people that throw crap out of the vehicle all the time, right? Okay? I think there's a problem with this statute. And while I'm on it, let me just get on my soapbox a little bit further. How about these license plate readers that don't ever catch the face of the person? Or these speed trap cameras that catch you going through certain towns? Do you know where the person is that's sitting there watching those cameras? They're in Tennessee and other states. How can I confront my accuser if I'm confronting a camera? Can I confront that? Okay. Basically, y'all write me a ticket for this because I'm coming to court and I'm going to fight this ticket. All right?
I wouldn't write him a ticket for this, for y'all.
I promise you. If I get one of those tickets from another town, I'm going to fight that ticket on the constitutionality. I think that this is a real problem. I think that this is probably going to have some problems. I cannot tell you how I'm going to rule if this comes up in front of me, but I bet you can guess.
Okay, have y'all seen the commercials, the Domino's commercials, I think, with the no driver in the vehicle? And I saw a YouTube or a Facebook Live video the other day. Some idiot was in New York City and he's Facebook Live and he's like, hey dudes, I'm fixing to take my first driverless Uber ride in New York City.
How many of y'all are going to get in a driverless car? Let me know. Raise your hand. I want to check you into the insane asylum.
So this statute says that a motor vehicle with one of these autonomous technologies doesn't have to have the same equipment, or they don't have to follow the same equipment laws or regulations as a regular vehicle does. So we've thrown out a few scenarios. So let's say you got a guy who has one of these cars. He goes to the bar, gets fallen down drunk, probably blow a .25 or 3.0, gets in the back of his car and says, take me home. Is he in control of that vehicle? Yes. You think?
You sure?
What if his vehicle runs a stop sign and hits somebody and causes serious injury? Y'all don't think that, okay, so what happens, y'all be honest, you patrol guys especially, what happens when you roll up on that crash and home dude's in the back seat saying, I wasn't driving? What are y'all gonna do? You're gonna think that he got in the back seat of the car, right? I mean, you're not gonna think that he wasn't driving the car. So I don't know where this is going. I think that it's gonna be a problem on down the road. These cars are supposed to have cameras on the back glass that when they see blue lights, when they sense blue lights, they're supposed to pull over. Apparently they don't work too well. Los Angeles County in California had a chase. I don't think the car was going that fast, but they had a chase where the car wouldn't stop. So they had to pit maneuver the car to get it to stop, and they damaged one unit that did the pit maneuver, and then I think it hit another unit. So they had two damaged units because the car wouldn't stop. Because it was supposed to, but something wasn't working correctly. I can see all kinds of issues with this kind of stuff, but let me tell you something. If I meet a car in Athens, Louisiana, where I live, then there's no driver in it, I'm probably gonna be the one that runs off the road while I'm trying to call 911 saying there's something bad going on in Claiborne Parish.
If y'all see one of these cars, please take a picture of it. Yes. Follow it long enough to get a good picture of it, because we're going to use it.
And we're going to add it to our slide presentation. Okay, search warrants for medical records. They amended this August the 1st. If you've got a case, let's say you've got a case here in Bossier Parish, and you need medical records from a facility in Red River Parish, you can get either a Bossier Parish judge to sign your warrant, or you can get a Red River Parish judge to sign your warrant, either way. And obviously, it's probably gonna be easier for you to get a Bossier Parish warrant, a Bossier Parish judge to sign it, but you can do either one, and you've got 180 days to execute that warrant, just like a DNA swab, a buccal swab warrant. So you've got 180 days to execute that.
Okay, let's stop for just a second. Let me talk about the book before we go into case updates. The book, if you will notice, is a little bit leaner and meaner this year. All right, that's what I like to say, a little bit leaner and meaner. First chapter has Tammy's tips in it, really good tips for if you're going to the courtroom. Third chapter has got some traffic stop matters in it that you'll be able to look at. Fourth chapter, of course, is search and seizure. The fifth chapter is a chapter that we put together. We tried to add tables in there that if you're talking to a person in custody, we put the case law in there. If you're talking to a person that's not in custody, what you can do. We tried to put in the 48-hour time period, the 72-hour time period, what the requirements are. So we tried to streamline this book this year. If you look at the law section, we took out all about the relative felonies. We've taken out about the sentencing guidelines. That's not important to you. We believe that what's more important to you is to understand what the elements of the crimes are. So we put in there more about the elements of the crimes, what you can charge a person for, how you can charge a person. If you look on page 141 and 142 of this book, instead of highlighting and shading where a law has changed this year, we put explicitly where the 2022 laws have changed and how they've been amended, so that you can go to that section and say, hey, this law has changed according to this. And that way you can find it real quickly. The main thing about this book is we want you to be able to put it into your unit and be able to rely on it in your unit so that you have a ready source and it's more available to you for that source. Now, if you look on the back page, it has our contact information. You'll see my personal cell phone number, Tammy's personal cell phone number, and our email addresses. We put those on the back page so that you can contact us with your questions at any time. Typically, we will answer the questions as quickly as we get to those questions or as quickly as you call us, or we will call you back. Sometimes I'm out hunting and fishing. Not as much anymore as I used to because I'm always talking to people, but the other side of it is I will get back to you as quickly as I can. If you ask me a question because I am a sitting judge in Bossier, Webster District, all across the top parishes of the state, please ask it to me in a hypothetical situation. Just tell me hypothetically speaking. People in here do it all the time. Okay, that's not a problem. I will try to direct you. I cannot tell you to arrest a person. Tammy can't tell you to arrest. We can't tell you exact things because you're the one that has to make that decision, but we will try to direct you where to go. Tammy is usually available on most occasions. You can ask her specific questions, especially when it relates to divorces and land property issues that are going to come up during trespassing.
Don't call me about that crap.
So, I always good one on that. But the other side of it is, please feel free to contact us with your questions or anything else. If you have something that's coming up that you think we need to know about for the legislature, also let us know about that. So, we've tried to streamline the book, just wanted to kind of go through that with you real quickly. Unanimous jury verdicts. Let me tell you where we are on unanimous jury verdicts. Ramos, y'all know, came out. Ramos said we had to have unanimous jury verdicts. All right, and basically, we have gone to unanimous jury verdicts. It's made it a lot more difficult. 11-1, 10-2 verdicts are not allowed anymore. We have gotten a ton of cases at the Second Circuit that we had to send back because the United States Supreme Court is the United States Supreme Court. Well, then they looked at Benoit. Benoit was whether or not we're going to apply that retroactively. The United States Supreme Court said this: for the federal level, we are not retroactively going back and trying any cases. 10-2, 11-1, if they're at the federal level, no problem. But we got a problem in the state of Louisiana. State versus Reddick is right now pending before the Louisiana Supreme Court. Louisiana versus Reddick says this, State versus Reddick basically asks this: if it was an 11-1, 10-2 decision, does Ramos apply retroactively for the state? Well, how can that be? Well, you know, we have that Bill of Rights, Section 10 under the Bill of Rights, that the 10th Amendment, which says those powers not reserved to the United States are reserved to the states. We can't take away any rights under the Bill of Rights, but we can grant more rights than are out there. So this case is pending. What does that mean? If they go back and allow retroactivity on these cases, some 30 and 40-year-old cases may have to be retried, okay? So this is where I say to you, write good reports. Who, what, when, where, how, because you don't know when these cases are going to come back. There's 1,500 to 2,000 of these cases that may have to be retried, or else the DAs are going to have to do something, make some decisions as to whether or not they're going to retry those cases. Now, when I was at the district court, there was a case that had to be retried after 30 years on a murder case because the guy got a new trial based on something. I know Bert was there when it was retried, and it was riveting testimony because the officers had died, the witnesses had died. The only person that was alive was a 13-year-old boy, and at the time, and he had become an adult man, and he was wandering around the streets of San Francisco, and they couldn't find him. I know Mike remembers that too. But for, 4 days, you know what happened? They brought a law clerk in from the judge's office. They took the transcripts, and they would say, "What is your name?" "My name is so-and-so." And they had to go from the transcripts to retry that, and the police reports and the evidence that they had. If you don't do a good job, you never know when any of these cases are going to come back and when you're going to have to rely on that police report. Write good police reports, write good things about your case, put everything down, because it is very, very critical. We will see what happens with State versus Reddick. If it comes back, she is already getting letters from defense attorneys all over the state trying to make deals on these cases. But we will see what happens and how the district attorney's offices and how the judge's offices will be able to handle this, because it is going to cause a huge glut of cases that may have to be retried.
Okay, so in this case, it just came out this summer and just very, very recently. They had a guy who called 911. He saw a man in a car who was threatening the passenger of the car and then took some pills from the passenger of the car. The man that called 911 wanted to stay anonymous, but he described exactly what the guy was wearing, described what the passenger was wearing, and it wasn't very long after that that the police showed up, and they observed exactly what the 911 caller had said. And the issue here was whether or not the 911 call was reliable enough. And the court, they stayed with what they had been saying in a lot of our Louisiana Supreme Court cases as well, like State versus Elliott, which happened here in Bossier Parish, that even though they did not see anything, any kind of criminal activity going on, they got there, the police got there, and they could rely on that 911 call. The 911 calls, even if you want to stay anonymous, or y'all know as well as I do, you're really not anonymous. They've got your phone number, might have your name, depending on how you call, and they have your location most times. So that they said in this case that the 911 call was reliable and the tip was active and it was going on as the police got there. Okay, and Mr. Dennis was being surveilled by the Department of Homeland Security, and the way they were doing that was they put some pole cameras up around his house. And they caught him with trucks coming into the garage, and he would unload things and then he would load things back up. And they surveilled him for probably April to July. They finally hit the house with a search warrant. They ended up having to shoot Mr. Dennis because when they hit the house, he had a gun in his hand. So they shot him, didn't kill him, obviously. And they found over 111 kilograms of marijuana, $200,000 in cash, and some other guns and things like that. He filed a motion to suppress, saying that the poll cameras were a violation of his Fourth Amendment rights. And the Fifth Circuit held that in this particular case, he had a fence around his property, and they didn't really describe the fence in the case, but I'm assuming it was one of those fences that you can see through, because the court made a point that the public could see everything that the poll cameras saw. So anybody walking down the street could have seen what was going on in Mr. Dennis's garage and his driveway. So they made that distinction that if you kind of hold your property out where the public can see it, then it's not a violation. So in this case, they denied the motion to suppress. They did not discuss how long they surveilled him, the fact that it was 3 months or so, and they said that that may be an issue in the future, but in this particular case, it was not an issue. The only issue was whether it was a violation of his Fourth Amendment rights, and they decided that it was not.
In this situation, Mr. Bowden was a defendant with his girlfriend. They were doing what I like to call recreational pharmacy. They were driving drugs up and down the highway. And basically, the way that the officers found them is they got a warrant to obtain the GPS information for the girlfriend's cell phone. Well, when they went to court, they filed a motion to suppress on the GPS evidence that was found from the girlfriend's cell phone. The court denied that motion to suppress, and the defendant ended up pleading guilty and getting a pretty lengthy time in jail. He appealed that motion to suppress, the denial of that motion to suppress, and went up to the Fifth Circuit Court of Appeals. And basically the issue was whether or not that he could expect privacy in the girlfriend's cell phone. The Court of Appeals looked at that and said this guy didn't have rights to that cell phone, he didn't have access to that cell phone, it was the girlfriend's cell phone, and basically there was no expectation of privacy. So they allowed the GPS coordinates on the girlfriend's cell phone, found him guilty, denied the motion to suppress, and said that the conviction stood. So in this situation, another person does not have privacy issues in another person's cell phone.
Okay, this is one I'm gonna get a little political about. The end result in this case is a good result, but the way that they got there, to me, is not constitutional, I guess. Facebook, in its own volition, reviewed the private messages of a guy. Y'all know that they're looking at everything we do, right? Especially if you are posting anything that is anywhere near on the conservative side of things, they are looking at your private messages to see what you're saying, who you're talking to, things like that. They did that in this case, and they thought that this guy was talking to a minor and that there might have been something going on that didn't need to be going on. They forwarded the messages to the National Center for Missing and Exploited Children. And the center looked at them, said, something doesn't seem right. So they forwarded it to the law enforcement department in the defendant's city. The law enforcement did the right thing. They got a search warrant. They got the private messages from that search warrant. Then, based on that, they got a second warrant and went and got his phones, his computers, and all that kind of stuff, and found child pornography, and all of that. Again, end result, good. Way they got there, to me, not so good, because they can do the same thing to me. I mean, I'm not communicating and doing anything wrong, but if they think that a message that I send to somebody on Facebook doesn't comport with the way that Facebook and the guy that owns it believes, then, the FBI could show up at my house maybe. I don't know. So Fifth Circuit held that Facebook was a private actor, because the guy argued that Facebook was working for law enforcement. But they found that Facebook was a private actor. They did this on their own. Law enforcement had nothing to do with it. They didn't even know it was going on. And so therefore everything was okay. And the center, even though it's a government agency, its review of the messages was still not a violation. It was not a search within the scope of the Fourth Amendment. So it was still okay, and this guy got convicted of this and is hopefully doing some time.
Mr. John Lewis was receiving some drugs at his house, and when the Postal Service worker went to the house, there was a convenient hole in the package. and her thumb slipped through the hole. And based on her knowledge, training, and experience as a letter carrier, and because of prior family members, she knew that there were drugs in that package. She contacted the local authority at that point. They came over, they obtained a warrant, went into the package, and of course there were drugs in the package. Mr. John Lewis was arrested. Mr. John Lewis filed a motion to suppress that because he said what? The Postal Service worker was a government employee. We know that the Fourth Amendment says there can be no government intrusion into a private place under the Fourth Amendment. So we all agree she is a government employee, right? Okay. But the issue was this: was she a government employee that the Fourth Amendment applied to? In this situation, they said no. Why did they say no? Because she didn't have investigative authority, she didn't have arrest authority, so she did not apply to her. If she had been somebody that could have inspected this, arrested for this, or anything of that nature, then that would have fit under the Fourth Amendment. So if you get a local postal employee that calls you at the Drug Narcotics Force and tells you that their thumb slipped through a package and they felt like it was drugs, you may be able to get an arrest warrant, okay?
Some of these cases are crazy. This one's yours.
Oh, this case I still do not understand, but you know, I'm not at this pay grade, so. All right, the officers were conducting a statewide roundup of known gang members, and they had outstanding warrants, and they were provided with this information that they were told to be looking for a Hispanic male who had run from officers in the past. He was on a bicycle with large handlebars, and he was in the area of Leopard and Upriver. So they didn't have any other identifying information, but when they went out there, they found the defendant who fit that description, and he initially ran from the police officers. When they got him stopped, basically what they found on him was that he had a pistol and ammo, and he was a convicted felon in possession of a firearm, so they arrested him. This goes up to the district court. District court looks at it, says, they filed a motion to suppress. District court looked at it and said that was sufficient information to be able to arrest this person. Goes up to the Fifth Circuit Court of Appeals, the most conservative circuit in the United States, and they reversed this. They said that that was not a sufficient description. They held that reasonable suspicion to stop somebody of suspected criminal activity is a low threshold, but it has to be founded on specific and articulable facts rather than a mere suspicion or a hunch. And basically they said there was no physical description of this defendant, it was not specific enough, and they basically granted the motion to suppress. And then they added insult to injury, I believe, when they said open-ended description would effectively authorize random police stops, something the Fourth Amendment awards. Well, in my opinion, this guy is in the area, fits the description generally, and basically he runs when they try to stop him. I don't know what's going to happen with this case. Maybe it'll go up to the Supreme Court. We'll see what happens, but basically I disagree with this opinion in this case.
Okay, so this is a lawsuit that was filed, and the defendant had felony warrants. He ran into the woods and they deployed the canine. Canine catches the guy after about 200 yards, brings him down by biting his wrist. Law enforcement gets there and they subdue the defendant, and at that point the handler gave the dog the command to continue biting. And on top of that, he kicked the defendant. So they, obviously the guy sued, and he said, because the court takes the defendant's version of the facts to be true in these cases, and the court found that it was reasonable to conclude that the police dog, the order to give him to continue to bite after he was subdued and kicking him constituted excessive force in violation of his Fourth Amendment rights. So if you are a canine handler, and if your dog, I got two buddies that are Minden PD canine, and one of them told me the other night we were teaching them, he said, we're trained that when you hear click, click, behind their back, you better start counting 1 million, 2 million, 3 million. Y'all know what that means? It's how many dollars they're gonna get if the dog doesn't come off, right? And he said sometimes his dog won't release. He has to physically go get him and pull him off. If we feel like, and we even talked, and Glenn Langley was with us Tuesday night, and he agreed, if you're on your body cam or you've got other deputies there or officers there with you, and they can testify that you were given the command for the dog to release and he didn't release, so you went and physically removed him, we think you're gonna be fine. But don't give, after you've got him in handcuffs or after he's even just subdued, don't give the command for him to continue biting.
This is the case that I said I would talk to you about. You remember that little statute that they passed talking about malfeasance in office? The officer was not wrong for sending the dog in. But once they found that there was excessive force, you know that the person's arm was probably lacerated by the dog at that point in time. That constitutes serious bodily injury. Because that constitutes serious bodily injury, this officer now probably will face criminal charges. Not only a qualified immunity claim, but will now be charged with probably malfeasance in office at this point. So this is a case that I wanted you to know for an example of what we were talking about with a malfeasance in office kind of case. State versus Bell Brayboy. I know that y'all know about this case because it came through, well, it came in Webster Parish. But Mr. Bell Brayboy was trafficking a lot of drugs up and down the highway. And it went to the federal court first. At the federal court, there was a prosecutor that basically was supposed to handle the case, but he didn't handle the case that day for some reasons. The trooper got on the stand and there was another prosecutor in the courtroom. This all dealt with reasonable suspicion and how long the traffic stop basically took and the reasonable suspicion that the officer had based on his knowledge, training, and experience. So the prosecutor really didn't ask the correct questions in front of the court. The officer was not able to testify as to what he knew properly, and the court suppressed the evidence and dismissed the prosecution. When it came back to the state court, Schuyler Marvin decided to go ahead and prosecute the case. It was in Webster Parish in front of Judge Craig. It went to court, prosecutor asked the right questions, the state trooper was able to get the information in that needed to go into testimony. Basically, there was a conviction. It came up to the Second Circuit. Well, 2 judges wanted to overturn the conviction based on what happened at the federal level. 2 judges wanted to affirm the conviction. Guess who the deciding vote was? Me. Guess what I went back and I did? I went back and I looked at the police report talking about the officer's knowledge, training, and experience. And I highlighted the officer's knowledge, training, experience. That's why we tell you every year, put in your knowledge, training, experience, update your knowledge, training, experience. Now, how many of y'all know your district judges? Raise your hand for me. Pretty much all y'all know your district judges. How many of y'all know the 8 other judges I serve with at the Court of Appeal? How many of them know y'all? How many of y'all know your Supreme Court justices, all 7 of them down in New Orleans? Basically, my point is this. When I was at the district court level, I got to look you in the eye. I got to judge your credibility. I got to talk to you. Over at the Court of Appeal, all we have is your writing. All I get to look at is your testimony. All I get to do is look at your report. When I wrote in this opinion, I highlighted the knowledge, training, experience of that officer because when it went to New Orleans, that's what they were going to be focused on, I hope. And they did focus on that because Mr. Bell Brayboy's conviction was affirmed by the Louisiana Supreme Court in the last 3 weeks by a 6-1 decision, okay? So basically, write down everything, make sure you put in your knowledge, training, experience. The other thing about this is, just because they do not accept prosecution at the federal level, there are a number of cases that can be tried both at the federal and state level, and there's no double jeopardy. So do a good job, and it still may be prosecuted at the state level.
This is another case similar to that as far as reasonable suspicion to extend the stop. They had to wait about 15 to 20 minutes for the dog to get there. But Mr. Gooden was traveling down I-20 in the Washita Parish area, and they stopped him for a traffic stop, and they started developing reasonable suspicion to extend that stop. They got the dog there. He had wrapped gifts in the trunk of his car. Now, the backstory to this is law enforcement had known this guy, and this was how he transported his dope. So they started unwrapping the gifts. He told them he didn't want them to. They kept unwrapping the gifts, and they found he had candles that had meth in them and a hammer to bust the candles. Also had some PCP inside of them. So he moved to suppress the evidence, and the Fifth Circuit held that they had reasonable suspicion of criminal activity, and it was enough to extend that stop for the dog to get there. They noted his nervousness. Did y'all know I-20 was a known drug corridor? Because this circuit put that. The interstate was a known drug corridor. He claimed his itinerary, that what he claimed was going on was physically impossible for him to do, just different things like that. All of this stuff, like the judge is saying, was in the report. Prosecutor asked it on the motion to suppress, so it got into the record, and the Fifth Circuit was able to look at this and say, yes, there was enough reasonable suspicion to extend the stop. If you didn't put it in your report, what? It didn't happen, right? And your prosecutor for sure is not going to know that it happened, and they're not going to know to ask the questions. As a prosecutor, I need it in the report so that I can ask. If it's there, I'm going to ask you about it.
This is a case where the officer saw two men in a vehicle, and they didn't exit the vehicle. They're in front of a convenience store. They didn't exit the vehicle for 10 or 15 seconds. So the officer didn't see him getting out of the vehicle, so he decided to approach the vehicle with 5 of his other buddies in police units with their lights flashing. Okay, so they
I
pulled
call
up.
it a parking lot takedown.
Yeah, parking lot takedown. So they pull up around the guy, and the guy goes up, the officer goes up to talk to the gentleman in the car, and marijuana comes out of the car and hits him in the face. Plus he sees the guy in the other seat throwing something in his mouth. So they get the guy out of the car, and they notice a weapon in the car seat. Well, this is a guy that's been convicted before, so he's charged with the possession of a firearm by a convicted felon. Basically, this went up. They moved to suppress the evidence of the police of the gun because the person said that this was a search and seizure, that this person was coming up to do a search and seizure on him. This circuit held that the police officer had a reasonable suspicion of criminal activity to justify the detention. First of all, they found that there was no case in the Fifth Circuit that said that officers couldn't do this. Second of all, they noted that the tenor of the encounter was benign until the odor of marijuana hit the officer in the face. And then they said that the officer didn't even conduct a physical frisk at that point in time. The thing that I like out of this case is, it said in the Fifth Circuit opinion, if this course of conduct is constitutionally impermissible, then it's difficult to see how any active policing can take place in communities endangered and impoverished by high crime rates. So basically, I guess this means that you can go and talk to people in high crime areas like a Terry stop, and if you notice things like that, but I wouldn't probably suggest rolling up with 6 of your buddies and the lights flashing at that point in time. Okay, Coniglia versus Strom. Let me put it this way. This defendant asked his wife to shoot him. I would never do that because my wife may take me up on that certain days. All right? Yeah, most of y'all can relate here. All right, but the defendant asked his wife to shoot him. The next day, the wife asked an officer to accompany her to the home. The officer determined that that defendant was a danger to himself and asked him to go to the hospital. Defendant agreed, but on the way out the door, the officer sees the defendant's weapon. Well, of course, when the guy gets out of the hospital, he files a motion to suppress in a 1983 action saying that the officer violated his Fourth Amendment rights by taking his weapon and taking him to the hospital. This went up to the United States Supreme Court, all the way to the United States Supreme Court. The Supreme Court held the community caretaking exception to the Fourth Amendment's warrant requirement does not extend to the home. Basically, the officer's seizure of the petitioner's gun from his home violated his Fourth Amendment right against a warrantless search and seizure. Now, you remember the guy consented to go to the hospital. All right, so we go and say, okay, well, that's kind of crazy, but let's think about that. So then they came out with Sanders right after that. Basically, the law officers were called to a home after receiving a report of domestic disturbance with minor children in the home, which y'all get all the time. Law officers entered the home. When they heard the child crying, they went upstairs. Minor child informed them that there was a gun in the home. So they went downstairs and they searched and found the gun in a couch downstairs. Again, the issue is whether the community caretaker exception to the Fourth Amendment allows law enforcement to make a warrantless entry in the home. The Supreme Court of the United States again held and reaffirmed the prior ruling in Coniglia, and they noted that the officers may enter the home without a warrant if they have an objectively reasonable basis for believing that an occupant is seriously injured or threatened with such injury. So what do these two cases mean? If you believe that there's a domestic disturbance going on, if you believe that somebody's about to get injured, if you believe that there may be death in that home, you can go in that home and you can secure that home. But can you take anything out of that home without a warrant? No, not according to the Supreme Court of the United States. So what do you need to do at that point in time? Probably you need to back out, secure the premises. If you have to take somebody to jail, take that person to jail because they're causing problems, or take them to the hospital if they agree to that. The other thing is, if there's a wife that is there after you've secured the premises, you can ask the wife, can we take those guns into possession? Or go and get a warrant to go back and get those weapons at that point in time. These are two cases that came out of the Supreme Court, and it blows my mind, but I mean, basically, y'all are put into a bad position because, I mean, how many times are you called out to domestic disturbance calls that there's weapons that are in the house that if you leave that person in the house, they may use those weapons, okay?
Before we do that, the next case, we had a question about
Search
search
warrant.
warrants.
Yes, go ahead.
So the question is, and I don't know where it is, correct me if I get the question wrong. If you have a search warrant and you have a lawyer that calls and says, hey, that guy's my client, stop searching. You don't have to do that. If you have a search warrant signed by a judge, execute the search warrant. Same way with an arrest warrant. If you have an arrest warrant signed by a judge, execute the arrest warrant. If the person calls, y'all remember State versus Donovan Alexander from a few years ago? If the attorney shows up at the station, or if the attorney calls and you know he's an attorney, and he says, that guy that y'all have in the interview room is my client, stop interviewing him, then you have to stop interviewing him. But you don't have to stop if an attorney calls you and says, hey, this guy's my client, stop searching his residence. You execute that search warrant. Is there anything else?
That's it.
Is that
That answer your question? I think that answers the question. So,
anybody else have a follow-up?
yes,
On whether you can stop them from answering?
Yeah, when you question, if you call and
Yes.
say, hey, I'm attorney so-and-so, you have to verify that he's an attorney, or any question, or, because I think anybody can say,
Yeah, and we've had a question of, like, if an aunt calls and says, hey, I've hired so-and-so to represent him, no, I don't believe, I don't think.
You don't have to do
stop
that.
answering it, stop
the attorney
questioning
needs
that.
to identify himself. He may fax you a letter, he may send you an email or something like that, or have it sent to your office. You can tell him to shoot a letter or whatever, but you can continue until you actually know that person is an attorney. And Donovan Alexander, remember, the person showed up, showed them that his bar card, said he had represented Mr. Alexander in the past, and he identified himself as an attorney that way. But if somebody calling you on the phone, unless you recognize them as being that attorney, you can proceed forward until you know that that is actually their attorney. You go ahead.
Okay, so this case went all the way to the Supreme
How
Court.
many are in the jail in here? How many are in the jail? All right, y'all gonna love this case.
So this poor lady was arrested for shoplifting and she was taken to the jail. And the jail's policy was that they could perform an inspection and penetration of the anal or vaginal cavity by means of instrument, apparatus, or object, or any other manner whenever they had reasonable grounds to believe the detainee was concealing weapons, contraband, or evidence. So they arrest her for shoplifting. Shoplifting, and a day later, had some snitches come tell the jailers, hey, she's got drugs on her.
She had some crack in her crack.
So they issued a cavity search pursuant to their policy. She sued, saying that they violated her Fourth Amendment right to be free from unreasonable searches. I would agree. I think it's probably an unreasonable search, but so they went all the way up to the Supreme Court, and the issue was whether the Fourth Amendment permits jail officials to conduct these types of searches. The Supreme Court held that there were probably less intrusive measures that could have been taken, but stated that this was not the case to decide whether this kind of cavity search was necessarily unreasonable in light of the potential alternatives. But going forward, you probably need to consider less intrusive possibilities or ways to do these type searches. So I think what we learned from this is that if you have a jail policy like this, you may want to think about tweaking it just a little bit.
Brian Morton, this is a case that we taught at the academy in the last few years because of search warrants. Brian Morton was a person that was on the highway. He was stopped for speeding. When the officers stopped him, they smelled marijuana, and he gave consent to search the vehicle. When they searched the vehicle, they found 16 ecstasy pills, a bag of marijuana. They found a glass pipe, and they discovered children's school supplies, a lollipop, 14 sex toys, and 100 pairs of women's underwear, leading them to believe that this man was a pedophile. When the officers went and filed for a warrant, basically they asked to search the phone for any drug any drug connections or any drug photographs that were on the phone. But they didn't include anything about the sex toys, the underwear, anything of that nature. Okay? They filed a motion to suppress. It went up to the Fifth Circuit originally about 2 years ago. The Fifth Circuit suppressed the evidence found under that warrant because basically they didn't ask to search for these photographs that related to children. They asked to search for photographs and contacts related to drug paraphernalia and to drugs. When it went to the federal prosecution, they didn't even prosecute him for the drugs. They prosecuted him for being a child predator and for being in possession of child pornography. Just 3 weeks ago, the Fifth Circuit came back and did a rehearing on this, looking at that search warrant and whether or not that they found these photographs properly. The Fifth Circuit reversed themselves and said the warrant was sufficient in that situation because they were in that phone legally and properly, and basically that was improper for them to suppress the evidence. So they have now gone back and allowed the search to take place. And again, Mr. Morton, conviction has been affirmed because of that. The situation like this, though, what I suggested at the academy was this: put in all information. Basically, if you find things like this, you need to put in information like that you found these things and that you were looking for these things and any and all other criminal activity. There is a case out of the state of Louisiana. Y'all remember about the cell phone case where the guy stole the cell phone at the LSU game. They pinged it all the way to his house. They walk in his house. He's got his computer up. They see child pornography. They had a warrant to go search for the cell phone. They back out. They go get another search warrant for the child pornography. They start searching. They find other criminal evidence. They back out. They go get another search warrant. Louisiana Supreme Court held that that was a good search warrants because they acted in good faith. In this situation, if you were to find something like that, I would stop searching at that point. If you didn't think your search warrant covered it, go back and get a search warrant to cover it. Just protect yourself, because we don't want any more cases like this that we have to rely on a rehearing. But y'all have already covered qualified immunity. I tell you what, we're going to save you from that. Y'all know that qualified immunity, there are two cases that came out of the United States Supreme Court, Tahlequah and Rivas versus Balages. Basically, it was 9-0 decisions. Out of the United States Supreme Court, can y'all believe that? I can't believe they can even get in the same room sometimes. But basically, they said qualified immunity is here to stay. Okay, they said that they are not overturning qualified immunity, that as long as you do what you're supposed to under your training, as long as you have classes and you learn about cases and you're doing what you do in good faith, that qualified immunity is out there. Now, I can tell you this, guys, I know this, I don't have to defund the police. If I want to get rid of police, I just take away your qualified immunity. Because basically, every time you arrest somebody, you can lose your house, your cars, your pension, your inheritance, your income tax refunds, everything that you got. I can tell you there's not too many officers that's going to stay on the job. Now, I can tell you there's two people that are not going to, you don't have to worry about that if you're doing your job. Basically, if you're writing your reports and you're following your training, I can tell you I'm there to help you out, okay? And I'm going to do what I can. I'm going to follow the law, but I'm going to do what I can. There are people in this country that are not in that position to say that for you. So qualified immunity, that was a big deal when they passed that from the United States Supreme Court, saying qualified immunity is here to stay. Tammy and I appreciate the opportunity to be here. We wouldn't be here if we didn't care about you. We wouldn't be here doing this, because tell you what, it is a lot of preparation to be here and do all of these cases. Judge and Ms. Drew have been doing it for a long time, and they've trusted us with doing this. We care about you. Number one rule at night is we want you to get home safely, right? Number two rule, protect yourself. Always write good reports. Do what you need to do to help us to help you. If you see something that you need at the legislature, please let us know. And please stay in contact with us. We have our information there. Ms. Tammy?
Y'all can call me anytime, day or night. My phone stays on 24/7. If it's during the night, it may not come through. I do live in Claiborne Parish. We have 0 cell phone service sometimes, so just keep calling. It'll eventually come through, and I'll get up and answer your phone call. Y'all know y'all can call me anytime. My number's on the back. Like he said, you can call me and ask me direct questions about things, and I'll try to help you as much as I can. But y'all just be careful, watch your six, watch your partner six, and we appreciate everything y'all do.
And I know that I will probably run into some of y'all on the road, and if I do, just do one thing, say, peace out, brother, okay? Y'all have a good night.